Yes, Senator Wojciechowski.
I'd be interested in your comments on indemnification, because I think it's included in your brief, and it's the confidence that the board members have that they're just not out there on their own if they do make a decision. But and in your answer, can you look or at least comment on what would be the state supervision if we agreed to indemnification, what might that process look like as it goes forward? I'm thinking of a comparison with Goldfarb, where you had, the state bar was saying you can't advertise, but they were doing that for the benefit of the consumer. I mean, unlike NC Dental, it was just we're doing it for more money for dental cleaning. So there's a different fact pattern there. What that might look like on a time period.
Right. So as far as the indemnification scheme, first of all, I think that training is going to be a large part of that. I think that a board member should be aware of the fact that, this is what antitrust immunity covers. This is why it is so critical to have record keeping and the preservation of a record to show that you were articulating a policy in your decision. And then also, there should be the understanding that if you are acting separate from a state interest, you are not immune from antitrust decisions. Just because you serve on a board or as part of a program, you are not necessarily immune from all antitrust. And I think that that's important from a training perspective. As far as the indemnification scheme, considering the relationship between state law and federal law, there are ways that are discussed in the opinion that you could clarify or improve that process, like specifying that as a matter of state law, their antitrust awards that are trouble damaged are not considered punitive damages. These are ways that we could potentially clarify exactly what type of indemnification scheme would exist for boards in California. But overall, it's really understanding that this immunity only extends to the extent that you are operating on behalf of a state interest, and it's preserving an understanding of that.
I guess the question would, or the logical extension would be, if you are acting like a dental cartel and we do want to punish you, the decision is we're going to punish you individually, then the state would not be there. But if you simply were doing some anti-competitive, antitrust violations, and got determined that there was treble damages, that would be something that at least we could say was under the auspices of the state supervision?
Right, and I think clarifying what types of activities the state will vouch for in that setting.
Thank you, Chair.
And I did want to welcome Senator Galgiani to the hearing. Thank you for coming today, Kathleen. Question, in looking at trying to resolve the issue and where to place either greater authority with the director, or you mentioned the Office of Administrative Law, perhaps. Looking at the OAL today, are they established in a way that could do this and meet the standard that's required and necessary with the purview of their authority and what they're currently doing, or do we have to add some things to that?
I think as far as enhancing the role of the OAL, if you look at what the OAL's role is in a rulemaking process as opposed to the director's role as part of the Department of Consumer Affairs, really the OAL role is administrative. It makes sure that there are a number of procedural steps that have been taken to ensure open government and participation of the public in the rulemaking process. But when we look at the case law, it speaks to the fact that the active state supervision has to be in regards to the substance of that decision and not merely the way that that decision was made. So I believe that if we were looking for an existing government agency or entity with an existing oversight role into the rulemaking process by boards and programs, it would be more intuitive to place that with the director of Department of Consumer Affairs, because that role is already based on the substance of the decision and not merely the way that that decision was reached.
I see. Senator Wojciechowski?
No, I'm on your page.
Oh, good. The other question is, we've looked at a number of issues related. One is teeth whitening as a regulation, or however they defined that, and then the cease and desist letters that went out in their authority in that. And then we raised the issue of discipline And so it's not just an issue of anti-competitiveness in a direct, straightforward action. It's anti-competitiveness that could be in disciplinary cases or in others where you have a pattern of decisions affecting multiple licensees that could be developed, and that could be structured in an anti-competitive manner by the board or decided on that. So how do you see that all fitting together, and where do you think that could best be looked at and dealt with?
Right, and when the phrase pattern of decisions by a particular board is used to articulate, particularly risky behavior by a regulatory authority, it's interesting, and I think it's not necessarily the most applicable phrasing, because really there are specific code sections that are enforced by each of the particular boards. There are BNP sections outlining certain conduct that are regularly and routinely brought by that board against licensees. So if we were simply looking for, kind of repeated disciplinary actions initiated by the board on the same, types of violated sections of the BNP code or other provisions, we would be able to establish a pattern that wouldn't necessarily be indicia of anti-competitive behavior without state interest. I could see, if you were looking at the types of decisions that the director should have a greater likelihood of reviewing, that could be based on other types of behavior exhibited by a board that could be considered anti-competitive. But I think that if we're looking at a pattern of what types of discipline cases are taken by a board, I don't think that that's necessarily the most productive way of constructing a sense of anti-competitive behavior on behalf of any particular board or program.
So do you think every decision, or do you feel that every decision of the board should be reviewed by someone to determine its anti-competitiveness behavior or action or potential actions, and reviewed in terms of state policy?
I would definitely not be on the side of thinking that every action should be reviewed. In part, as a reminder, at each one of the board meetings, there's both an executive officer who is an employee of the state, and also staff counsel for the board is present as well. In addition to that, I think that, considering the great majority of cases before the board, both disciplinary and, otherwise, are not particularly susceptible to antitrust accusations or risks, it would probably, in the balance, not be worth automatic review by the director. One thing that could certainly be considered, though, is voluntary requests for review by a director. This could potentially be of great comfort to boards to know that if they are facing a decision that they are worried might be susceptible to accusations of antitrust by whichever parties are affected by the decision, they could request review by the director and have a little extra buffer of state supervision.
So you've implied or kind of referenced the director a number of times. And I know in the recommendations or the suggestions, one is a super agency that's a potential for there. Could you elaborate on the other choices or opportunities to meet this standard that we're talking about, and to for indemnification, and what your maybe arguments pro and con in each one would be?
Right, sure. So the so-called super agency is kind of the one that we've gravitated around because it's a way to simply build on existing infrastructure to add a few more safeguards. The other recommendations or options, one of which is training, which, as I've said, is something already underway and is an easy deliverable in response to the case decision. And then also clarifying the indemnification scheme that trouble damage antitrust awards aren't punitive damages. That's something else that could be considered. And then finally, the other option that obviously could be considered in light of this decision is the changing of board membership composition. Because of particular, in this case, it was when a majority of the members were active market participants, and that was specifically cited as one of the main factors in why it was decided that they were not necessarily acting on behalf of the state without adequate supervision to vouch for it. I'm reluctant to either call a recommendation or even speak too affirmatively about that option for a number of reasons. First of all, obviously, we have a number of boards and programs with a majority of market participants and licensees in California. And so I think that in the balance of what's necessary to respond to this decision, it might be a little more drastic than what's needed. In addition to that, as I think was pointed out in the FTC guidelines, there's no necessary guarantee that simply changing a 5-4 majority of licensees to a 4-5 minority would even rectify the problem. because while we have a decision specific to the facts in the North Carolina decision, we don't know whether or not the same type of liabilities would arise from simply a quorum of market participants, or even absent a quorum of market participants, whether or not there is some, particularly influential block of the board that's considered to be especially influential over the decision making, either through its expertise or its influence. So I believe that in addition to being drastic, it's also not necessarily a surefire way to correct an issue, which again, just to stress, is not necessarily even a critical issue to address for that level of shakeup.
So you feel that by placing greater opportunity options authority in the director would be one practical solution to this, or using the OAL as another solution that we could follow, or path that we could go down and look at that as well? Is that correct? That's what I'm hearing.
Yeah, I think that they're well-balanced considerations.
Okay, very good. Other questions? Yes. Very good. Thank you very much, Mr. Sumner. Appreciate your being here today, and please thank the Attorney General for providing this and the good work she's been doing. Thank you.
I'll call her back.
So now we'll go to the DCA and Tamara Colson. And Melinda and Howard. Yeah. Melinda, yeah, everyone's coming at the same time. All right, very good. I thought we were going to do one at a time, but that's and that was my mistake. So Director Kidani and Ms. McLean and Ms. Colson, thank you very much. It's good to see all of you. Thank you very much.
Members, good seeing you. Let me first thank the Attorney General's office for a very thorough and concise distillation of the very complex matter that's before us, and the nimble way of drawing contrast between how we are as the state of California with Department of Consumer Affairs and North Carolina, Senator, that you ably mentioned. So that will also guide some of the comments that my colleagues to the right of me, that will guide their words as we move forward with this testimony. But I just wanted to give recognition to that. Again, thank you very much for having me and allowing me to testify on this very important issue. My name is Howard Kidani. I am the Director of the Department of Consumer Affairs. In addition to myself, I would like to welcome two members of my executive team, Ms. Melinda McLean, she's the Deputy Director of Legislation and Regulatory Review, and Ms. Tamara Colson, the Assistant General Counsel of Legal Affairs at my department. We would like to thank you very much for the opportunity to join this informational hearing to discuss the North Carolina case, and recognizing that this case has had and will continue to have wide-reaching impacts to the nation and specifically my department. I would like to thank my legal affairs team for quickly developing strategies with the Attorney General's Office Antitrust Section. In addition, I have directed my legislative affairs team to work closely with the committee on potential legislative solutions as they come forward. Furthermore, we are in the process of vetting policy considerations from the options provided by Mr. Sumner from the AG's office, the opinions that will likely be discussed this next legislative session. After discussing with the boards, we look forward to sharing these policy positions with this body and engaging through the legislative process. Expectations of the testimony today, as my colleagues move forward with this, information about the impacts of the North Carolina case, the options for consideration proposed in the Attorney General's opinion, and our plan for going forward. To put this into context, I would like to provide a brief overview of DCA. For those that don't have the pleasure of really getting in deep with the Department of Consumer Affairs, it's very deep and it's very vast. And it is unlike other departments that are within this administration. We have 40 licensing programs, 26 boards, 10 bureaus, which now includes the new Bureau of Medical Marijuana Regulation, 2 committees, 1 program, and 1 commission. the department's programs to protect and serve California consumers while ensuring a competent and fair marketplace. They accomplish this by establishing minimum qualifications for licensure. They also license, register, or certify practitioners, investigate complaints, and discipline violators. These programs regulate more than 250 different businesses, professional and occupational categories, including doctors, dentists, contractors, cosmetologists, and automotive repair dealers. I got it out. Boards exist as semi-autonomous entities within the department, whose members are appointed by the governor and the legislature, with the authority to set their own policies and priorities. For example, the boards may pursue their own statutory changes through the legislature without approval from the department. The department's oversight of the boards is generally limited to administrative regulatory functions. However, the department provides public comment at board meetings, provides legal counsel, facilitates personnel and other administrative transactions, and investigates board activities. The department also has specific authority to review and approve regulatory changes and provide many other administrative services, including mandatory training to new board members and compliance with conflict of interest reporting requirements. As the director, I have limited authority to approve some board executive officer hires. I also have the limited ability to deny approval of proposed regulations, only if I feel that it would be injurious to the public health and safety or welfare of the public. Bureaus, unlike boards, serve under the direct jurisdiction of the department, and the bureau chiefs are appointed by either the governor or myself, the director of the department. Most require confirmation by the Senate. Bureaus must seek approval from the department prior to making any policy-related actions. I say this to draw a distinction between the different structures within the department. While the department may be comprised of many separate and unique licensing programs, we have created economies of scale that reduce costs and improve efficiency. To further discuss impacts of the North Carolina case on the boards of the department, I'd like to turn over to Ms. Tamara Colson, my Assistant General Counsel.
Thank you, Director Kidani. Good afternoon. Thank you for giving us the opportunity to address you today. North Carolina made it clear that state professional licensing boards are not entitled to immunity from antitrust laws in the same way as the state. Specifically, a board on which a controlling number of decision makers or active market participants are only entitled to immunity from antitrust actions if they act pursuant to a clearly articulated state policy to replace competition with regulation of the industry, and their decisions are actively supervised by the state. As we already heard today, our own AG has written an opinion to assist us with the understanding of the impacts of the North Carolina case. Additionally, the FTC has very recently issued guidance on this topic. DCA has recognized important lessons from these resources and is encouraging its boards to engage in best practices based on this critical guidance. Specifically, boards should continue to promote their primary mission of consumer protection in making decisions and articulate the public policy reasons for those decisions. Boards should identify when they are making a market-sensitive decision implicating antitrust issues. When making market-sensitive decisions, boards should conduct an analysis of the pro-competitive and anti-competitive aspects of that decision. Boards should utilize the applicable state processes which contain elements of state supervision. For example, our Administrative Procedures Act provides a state process, including state actors, for adopting regulations, as well as a process for licensing and disciplinary decisions. Boards should consider objective evidence related to the issues before them, not just information from market participants. The discussions, information considered, and reasons for decisions should be part of the board meetings and documented in the records reflecting the board's action, such as the minutes. Board members should understand that lack of immunity from a lawsuit for antitrust violations does not mean there has actually been a violation. DCA has been working to provide support and guidance to its boards regarding the North Carolina case and its impact. As Mr. Sumner already mentioned, DCA Legal Affairs early on partnered with the Attorney General's office, specifically their antitrust section, to develop a training for clients, which was held on September 21st. During this training, the Attorney General's office shared its expertise regarding antitrust law and the North Carolina case itself. Representatives of client boards had the opportunity to ask questions. Shortly before the training, on September 10th, the Attorney General issued her opinion related to the North Carolina case. That decision was shared with the clients during the training. DCA is preparing additional guidance related to the Attorney General's opinion and the FTC staff guidance. Information related to North Carolina is now included in our board member orientation training, which all board members are required to attend. The department's legal counsel is also actively educating board members by advising them of the significance of the North Carolina case, as well as the AG's opinion, specifically informing them of the differences between North Carolina and California's structure, and informing them of the findings of the AG, which identify areas of operation that pose limited exposure to antitrust violations. In addition, attorneys are advising boards on how to recognize antitrust issues and how to reflect the rationale for their decisions in a manner that provides appropriate documentation and record keeping. Boards have been encouraged to reach out to legal counsel with questions related to the North Carolina's case impact and any antitrust issues that they are facing. To discuss the options for consideration outlined in the Attorney General's opinion, I turn it over to Linda McLean, our Deputy Director of Legislation and Regulatory Review.
Thank you and good afternoon. Thank you, Senator and members. As the director mentioned, the department is actively evaluating the options for considerations that are contained within the Attorney General's opinion. And this is in an effort to identify the avenues of ensuring that California boards can meet the active state supervision requirement. Within that process, we did look deeply into those, and very similar to echoing the concerns, not the concerns, but the comments of the AG, is looking at things that seemed less drastic or more drastic. The department believes that the drastic changes in the California system may not be necessary to achieve active state supervision. One such option, which we mentioned earlier today, which is a super agency concept, which could be a standalone office with the full responsibility of reviewing board actions. As noted by the AG, care would have to be taken to avoid unnecessary duplication and minimize policies not adequately tailored to individual licensing areas. Furthermore, another example that, in our opinion, may not be necessary is reconstituting the boards to public majorities. We believe the subject matter expertise gained by having licensees on regulatory boards is important to our process. Moving forward, the AG notes that California is in an advantageous position to create mechanisms for active state supervision within our current structure. Specifically, the Business and Professions Code already contains a state policy for the department to protect consumers, to promote a fair and efficient free enterprise market economy. Thus, the principles guiding the North Carolina case are already in place in California, as discussed by our Assistant General Counsel. Therefore, we have taken concepts laid out by the AG, and we are currently vetting these concepts, which would, in our view, perhaps require less drastic changes. For example, exploring whether existing resources and minimal adjustments to procedures within the department might be converted to lines of active supervision. Another one is evaluating whether the director's role to disapprove regulations continues to satisfy active state supervision if the provision for an override may be by a unanimous vote of the board, assuming that it maintains its utility. And then also reviewing the impact of making the director's powers to review certain board decisions mandatory versus making his review available upon a request of the board. Moving forward, of course, we will continue to update the boards on developments in the antitrust area. We're actively providing legal counsel as the boards face antitrust issues and provide appropriate training as appropriate and needed. We do believe more work is needed, and as we continue to vet these policy considerations, we are committed to working with the legislature. As the director mentioned, I will be personally working with your staff, Senator, and any of the members here on these legislative solutions. We do, again, do echo the concerns of the Attorney General that perhaps that our current system in place is one that we are confident in, yet we're very open to considering other options that may be discussed here at the hearing today. At this time, we'll take any questions.
Very good, thank you. Yes, Senator Wachowski.
I have a question. I know at our 26 boards and 10 bureaus and 1 commission that have right now, we have an executive officer and we have an attorney there. Can you flush out for me if this attorney, or maybe this attorney that's there, needs more direction or more authority on if the board is on the precipice of taking an antitrust, making an antitrust violation decision? What is that role, and should we be looking at expanding that role of that counsel there at the board meeting?
I will take the first attempt at this, and then I will probably defer to a much more able legal mind than myself. So the role of the staff councils that serve the 40 boards, bureaus, commissions, programs are essentially staff councils. You know, they are employees of the department, but via attorney-client privilege, advise them through each course, policy-making, administrative decisions that need to be made, et cetera. Your question regarding should they be advising or could they be under current statute or structure advising a board once they hit that decision point, please don't proceed this way because you could be at risk. I don't know if we don't have that structure currently, you know, and that is going to require much more digging. I would submit to this body that I am comfortable right now with my current authority, you know, and which is why I do not disagree with Mr. Sumner in it's not it is serious in that we should look at this, which is Mr. Hill, I'm glad you called this hearing, but it's not critical because of my current authority. In that, I'll defer to Ms. Colson in how those attorneys would advise that client.
I think you're right, Director Kadani. Essentially, we have a staff of attorneys in the legal division at the department who are assigned to provide advice to specific boards or bureaus. Sometimes there's several of us doing it, depending on the particular issue and the volume. But the attorneys make every effort to advise their clients, push them in the right direction, assist them to coming to the right legal outcome, and do that very actively. We typically work very closely with our boards and have very close relationships with both the boards and the executive officers to assist them in that process.
So the problem with the current system is that the attorney is advising members of the board, not giving recommendations to the legislature or to you. They're saying the privilege is held by the director or the board members, right?
It's both. It's both. We have attorneys that we do advice for the department itself as well as the boards. So we are doing that.
Can I just, on a board issue though, so if I'll set up a scenario, if you were advising one of my boards, correct, that privilege is with the board, not the director.
That's correct.
I do, on numerous issues, I do have at least one counsel advising me. It serves that similar role, but to my executive office and executive team. So it's an interesting structure, but it does serve the boards and bureaus well.
So I forget who made the suggestion that if the director, if all the directors could voluntarily request that there was a review, if council was talking to 6 board members or 7 board members and saying, hey, we may have an antitrust violation here, and some of the active participants say we're okay with that, at least one person might be able to say, well, let's trigger the review here. Would that be enough of a state oversight? Because I'm looking at it from that lens. The state oversight said, we're going to train you about antitrust violations. We're going to have a counsel there. Counsel's going to let you know that. And any one of you can raise your hand and say, we'd like the director or somebody to review this decision that we made.
I think that from a legal perspective, it's certainly another layer of oversight.
Yeah, but
I have one question, Mr. Chair, on this. The non-participants, non-active participants, can make antitrust violations on their own. I see that people are concerned that if I have some skin in the game, I may want to act like a cartel and make more money. But members of the public can make decisions that will have a violation of the Sherman Act. I just got to say that because changing the composition doesn't necessarily, because everybody gets lobbied, we get lobbied, they get lobbied, and they could make a decision. So I'm leery of, and I guess I'll draw the attention to Justice Breyer's remark and the Attorney General's footnote about, I'd like to have brain surgeons regulating other brain surgeons, not members of the public. And this is part of the majority decision that they had. So I'm concerned about the sort of the quick fix. Let's just get the active participants out when really anybody can make an antitrust, a Sherman Act violation in public.